Well, great welcome to today's National Immigrant Women's Advocacy Project webinar, Yes We Can, Public Benefits for Immigrant Survivors. We're glad to be able to have you join us, and as you can see, there's many co-sponsors of this webinar, and glad to have you joining us today. Please note that this project is supported by grant number 2011-TAAXK002, awarded by the Office of Violence Against Women, U.S. Department of Justice. The opinions, findings, conclusions, and recommendations expressed in this program are those of the authors and do not necessarily represent the views of the Department of Justice, Office of Violence Against Women. So I want to talk briefly about how to use this technology, just so people can be familiar with how we are working together in doing this work. And so the way we will do that is, the first thing I want you to be able to do is to raise your hand. And the way that you raise your hand is, if you look above my picture in the far left hand corner, and there's a little hand there, and underneath it says My Status, go ahead and just raise your hand. This is a great way that you can be able to participate. We might be asking questions later on. I see that of almost 200 people, less than a quarter of you have raised your hand, but more and more are doing that now. And it will just say that. So great. I will be lowering the hands. I see a lot of people doing it. I'm going to lower everyone's hands right now, but it's just a great way for us to be able to do it. A few more of you are still raising there. We do have a text chat. The chat is actually now on the right-hand side of your column. The way the chat works is that where it says type a message here, you click there, and then you will check here. You also can send private messages to people, and if you want to be able to do that, feel free to do so. You just click on this private tab, and then click on the name of the person that you want to send the message to, and that's a way that you can be able to be able to talk. You can ask questions on text chat and comment as we're going. We did get a sense of doing it. There is a lot of great valuable information that we're able to get in the text chat, and many of us are here working on this. There are the PowerPoint slides. I did get off. Just 1 second. Let me get rid of that hold message.
All guests have been muted. You can unmute your line by pressing *6.
Okay, so we don't want to hear anyone's hold music. So Leslie, if you can press *6 to unmute your phone, and we will test your sound in just a second. Hello, are you there, Leslie?
Yes, I am.
Okay, great. Thank you. We just once we hear someone who gets some music in there, we'll immediately mute everyone's lines. So we do have the copies of today's slides are available, and I will post that. I don't have it right in my hand here, but I will put that into the text chat very shortly, so you can get a copy of the slides. And these are all available on the New App website. And we'll be doing some polling questions a little bit later on. And for the phone, you are listening on many of you are listening on the phone. That is a way that you can do this. I will put the piece here, another way to get audio if you're not getting the audio on the computer, and that's how you can be able to get the audio. When we take questions, you can ask a question either in the text chat, or you can, if you are calling on the phone, we can unmute your phone. So that is something that we can do later on as we move in to this. We do have the captioning also, as you can see, going on the bottom, or you can press the captioning for the in this session if you need to. If you have a question about the technology, you can send us a private text chat, or you can call iLink Technical Assistance at 800-799-4510. So with this, no further ado, I'm really pleased to be able to introduce today's presenter. We have Leslie Orloff, who is the director of the National Immigrant Women's Advocacy Project over at American University Washington College of Law. So Leslie, I'm really pleased to have you for such a great topic today.
Thank you very much. Great to be here. Thank you all for joining us. So we're going to start. This is the fourth of a series of 5 webinars. We expect that our next webinar will be probably late summer, early fall, and will be on sexual assault issues. So thank you for joining us. We wanted to start off by getting a sense of who's here. David, you want to do this?
Yeah, let's go ahead. So let's get a sense of who's in, just a little bit of the roles of people in the audience. What I'm going to do is I'm going to give people an ABC choice on the left-hand side of your column, and let us know, are you a lawyer or an attorney? That's A. B, are you a domestic violence victim advocate? C, are you a sexual assault victim advocate? And D, are you a government benefits or other staff? And if none of those categories work, go ahead and try not to write A, B, C, or D in the column. Put that into the left-hand side. But if it's different, go ahead and write it on the text chat. So Leslie, let me just let you know who is in our audience today. And let me just share the results with everyone. We might as well do that. More than half of our audience are domestic violence advocates. And we have, looks like a little bit, almost a third of our audience are lawyers or attorneys. And we do have a little, looks like about a little bit of sexual assault advocates and a fewer on the others, and other people are writing in that they're both Bureau of Indian Affairs, victim witness advocate, public affairs paralegal, around immigration, anti-trafficking case manager. If you press the letter, transitional housing, domestic violence group coordinator, sexual assault therapist, someone from the Washington State Coalition Against Domestic Violence, consular assistant in the Consulate of Guatemala, a BIA accredited representative, another person from a coalition. So we've got a wide variety of different people that are working from a wide variety of fields. Legal aid, I see, is in here. So Leslie, we've got a pretty diverse audience.
Great. And I guess I should tell you a little bit about myself as well. I started my career as a family lawyer and have been involved in the public benefits aspect, or public benefits relief available for immigrant survivors since we started developing that relief in the early 90s, the mid-90s. So we're here to share the information we have, give you up-to-date information, including things about what's available through healthcare reform and other things like that. So thank you for joining us today. Our learning objectives are going to be, by the end of this training, hopefully you'll be able to identify what forms of assistance are available to undocumented victims. We're also going to be talking about how to screen for VAWA, T, or U immigration relief, which helps victims begin a path to becoming lawfully present, or what they call, and hopefully in the lingo, PRUCOL, which is persons residing under color of law, and we'll talk about what that means, and identify the differences in public benefits between VAWA self-petitioners and VAWA cancellation of removal applicants, trafficking victims, and U visa victims, because this is one of the areas of law where there are dramatic differences between the form of a relief a victim may be seeking. What I'd like to do is start off to get a sense of what, why you all joined us today. What are some of the issues and barriers that you're seeing in your states when you're working with an immigrant victim who is interested in, or you're interested in helping her figure out and access public benefits or state or federal public benefits? So if you could give us a sense of what is happening in your community, that would be really great.
So once again, please write in the text chat what barriers are present when an immigrant seeks federal or state public benefits. And I see people are already responding. Fear of deportation has come up immediately. The time that it takes to get a U visa, retaliation from a perpetrator, language barriers of limited proficiency, limited access to resources, fear of, so a theme I'm seeing, Leslie, is a lot of fear of deportation, language barriers, and some...
a 5-year bar as well that somebody raised.
Yeah, and so it's just going, a lot of fear of deportation seems to be a common one. Access to services, and just fear is perhaps the word. If I were doing a Wordle of this, I think fear would probably be the most common word that I'm going to see. And then there's some around language barriers seem to be there, and people are writing in a lot of comments, so it's kind of hard to read so many comments. But Leslie, I think we see to do with a lot of people are concerned around the eligibility for public benefits, which I know you'll be talking about here. At least there's a perception often that they're not eligible, and that clarity would be helpful.
And David, a couple of people are talking about the fact that in their states, although people qualify, they're getting turned away or you're having trouble accessing it. And we'll be talking about part of the reason we're doing this And maybe I'll just mention right now, when you go to the Go link we gave you that has the PowerPoint, it also has lots and lots of links to documents that will help you if you're walking in with an immigrant survivor and seeking to help her get benefits. That's part of what this is about, is to let you know what's available to support you in that process, because it is not unusual for you to be walking in with the victim with more information than the benefits worker is going to have in your community. Okay.
I'll put that Go link into the text chat, so I just put it right now, Leslie, so people can see where all these materials that you'll be referencing today are available.
Great. So these are some of the common things that we see. Language access you all got. I talked a little bit about tools. One of the things is that this is a very complex area of the law, so that in order to get benefits, it depends on your immigration status. So people have to kind of work through the immigration status piece first and then the benefits. And the other thing that I saw some people raising in the text chat is that there was this fear of public charge out there in the community. And what that means is that generally if you're an immigrant, if you get benefits, it can impede your ability to get lawful permanent residency. The good news here, and we'll be talking about this more in a bit, is that VAWA 2013 created an exception to public charge for VAWA self-petitioners and VAWA victims generally, for U visas and for T visas, and for trafficking victims. So that problem will go away, and our messaging and education of clients will become much easier because it won't be as complex as it used to be. And the final thing is that the other thing we hear a lot is about an apparent conflict between state and federal laws. And I'll get into what the states are legally able to do and not able to do in terms of any limitations on public benefits that are federal public benefits and what happens in their states. So one of the things that, so we have the Go link now on the screen. What you will see when you go into the screen, and feel free if you'd like to go back and forth if you want to open up, I don't know how techy you guys are, but if you want to have the web library open next to it, that's something we encourage you to do. But you'll see there's government documents and statutes, there are screening tools, and there are state-by-state guides. We've done state-by-state guides for all kinds of benefits, and we've done them for driver's licenses. So they're all up there, and you can look at the state-by-state charts. Okay. So to start, when we talk about benefits classifications, it's different than kind of immigration status. And so what happens is people get what benefits they can access. And when I say public benefits, and I'll get into this a little bit more later, public benefits are things that are benefits and services, usually financial payments and things like that, are licenses that are available from the state. So there are lots of federally and state-funded programs, like all of the ones we work in, that are not considered federal public benefits. They are funded by the government and available to everyone. So we're going to be talking about what undocumented immigrants can get. That would include immigrants who are in the process, let's say, of applying for a VAWA self-petition, or they have applied. U visa victims are considered essentially undocumented until their cases are approved, unless you're in a state that treats them otherwise. PRUCOL is something called persons residing under color of law, and what that basically means is you're here, you filed an immigration case, DHS knows you're here, and they're not deporting you. You're here. And so victims, and VAWA victims, VAWA self-petitioners and U visa victims who filed their applications become PRUCOL. And that's important because many states will give some public benefits to people who are PRUCOL. The next category that gives slightly more benefits are people who are lawfully residing in the United States. Now, lawfully residing in the United States includes VAWA self-petitioners who've received what's called a prima facie determination, and we'll talk about when that comes in a case, and U visa victims once their U visa is approved. Then there's another category called qualified immigrants, and we'll go over this. Those immigrants get even more benefits. They get access to post-secondary educational grants and loans, public and assisted housing, and depending on when they entered the United States, they'll get access to TANF, Medicare, child care, Medicaid child care, SSI, and food stamps. And depending on other program eligibilities, and we'll go through those each individually. And then there are U.S. citizens who don't have restricted access other than time limits and things like that that were imposed by welfare reform. So persons residing under color of law. This is a benefits eligibility category, and it refers to people who are in the U.S. and DHS knows them and they're not likely to be deported. We have materials in the web library that we're sending you to for these materials. There are all kinds of materials, including policy guidance from the Department of Homeland Security that talk about who is likely to be deported and who's not, who's likely to be a target of immigration enforcement and who's not. And those materials are available to the website, and if you were not on one of our earlier webinars, that webinar is available for download. These are fairly large. All the webinars are available for download. They're fairly large files, so they might take a while to load, but you can view them at later dates. Lawful presence. Lawful presence is similar to PRUCOL, but it is it applies to a more narrow group of immigrants, and it includes people with deferred action. As to healthcare benefit, as you may all be aware, the one group of healthcare of people with deferred action who do not get access to healthcare are children who've the DACA youth and children who are deferred action for childhood arrivals. But generally, all the VAWA self-petitioners or trafficking victims who have, or U visa victims who may have deferred action, those people would be considered lawfully present. But U visas would generally not have deferred action. They would have to wait until approval. So it's a prima facie determination in a VAWA case, in a VAWA self-petition. It would also include people on work and student and tourist visas. So those of you, let's say, working with sexual assault on campus, you might have somebody with a student visa who would be considered lawfully present for public benefits purposes, which basically means some access to health care. And then various different, some people who work where there are large Salvadoran communities might see a lot of clients with TPS, and people with various visa petitions that have been approved. And children, also you might see children who are victims of sexual assault who have applied for special immigrant juvenile status. And so what happens is that the relief you get, the amount of different kinds of benefits you get grows as you get progress through the process of getting different forms and more secure forms of immigration relief. Would be the simplest way to talk about it. And that for the cases that we're talking about, by and large, the trafficking victims you'll be working with that have either T visas or continued presence, which is an application that the prosecutor can file for, or they have to actually seek it from federal law enforcement, that those T visa victims will have access to public benefits, greater access than even VAWA self-petitioners. The second largest group is VAWA self-petitioners, VAWA cancellation of removal, and VAWA suspension of deportation applicants. Both of those groups are considered qualified immigrants. Qualified immigrants get access to federal public benefits, some access depending on various different eligibility criteria to federal means-tested public benefits like TANF. And then there are some state-funded benefits that on a state-by-state basis, states have a range of choices, and we'll be talking about that in a few minutes. So let me ask another question. How does lack of access to public benefits and work authorization affect the immigrant survivors you work with?
Well, thank you. Let's ask everyone to write in the text chat. Please go ahead and write down, how does a lack of access to public benefits and work authorization affect immigrant survivors? So Leslie, I see people are starting to come in. They're less likely to seek advocacy services. They stay in unsafe situations, become dependent on abusers, and dependent on abusers, lack of housing. So I'm being forced to work illegally, no money, no employment, lack of self-sufficiency, poverty, hardship, unable to leave relationships. So I'm seeing that theme, a lot of poverty issues and not being able to work, and dependency, and a lack of confidence, staying with the abuser, dependence, and greater risk, a lot of housing and...
David, may I ask a question? Could we have people raise their hands and tell us how many of them are working with victims that choose to stay with their abusers because of these lack of access to benefits?
Great. Go ahead. Raise your hand if you are currently working with someone in this situation. Right now, let's see, I've got 40. Well, let's keep on voting. The numbers are going up. We're at over 70 people have raised their hands so far, and I bet it's going to keep on going up. Okay. Yes. I didn't mean to cut you off, David. And we see that there are barriers and that it depends on the abuse of their financial issues. There are a lot of different issues that come up for immigrant survivors. David, I'm trying to put the page down and it's not working. Oh, because now you can. Okay. So let's take a vote. I mean, it seems that some of these are things that you have already. Keep typing in while we talk if you'd like to. We'd love to get a full picture of this. It helps us in our public benefits work to understand from you all what you're seeing in the field. So can you describe, I'm going to turn this over to you, David. Yeah, let's just see on the left-hand side, people are voting here. What best describes the situation in the lives of immigrant victims who can't access? Is it that they stay with an abusive partner or employer, face homelessness, interferes ability to seek help and work with law enforcement, or all the above? And the results are kind of clear. Let me share them, Leslie. Overwhelmingly, all of the above, and I can see a lot of people writing D going on, and just a little bit of the others, but mostly all of the above, Leslie. Okay. That's, again, very helpful for us to know and to understand. Okay. So let's now shift over. Thank you all for participating. You'll have many more, hopefully, opportunities to do so. So let's start with this. What services and programs and benefits can undocumented immigrant survivors legally access? What have you guys seen in your states that people can get? We see WIC, EMSA. Is that, I'm not sure what that is. Okay. Privately funded programs. David, you're better at this than me. Right. We've got WIC, protective orders, emergency Medi-Cal in California, TANF, child care, children can get health care, SNAP under their children only, food stamps for children who are citizens, DV shelter, U-Visa, so SNAPs, WIC, health insurance, food share, DV shelter, transitional housing, WIC, TANF. So I think we're getting a pretty much theme here of, and some of this might be interesting as it varies depending on where people are from. A lot of people are saying that DV shelter is available. And so school for children, that's a really, Rebecca points out, and ESL classes and counseling and DV shelter. So Leslie, interesting. Right, and then we see people who are talking about as to healthcare, birthing services only. That's true. Good. It sounds like, and that people are getting protection orders. They can get transportation, all the family law issues, emergency healthcare. Exactly. Okay. So that's great. So let's talk about the next point, and I think I might have given you a clue to this. How many of you, in terms of yes or no, are receiving public benefits? Will that harm a victim's ability to get an immigration status? Okay, so go ahead and vote, and let's just do some live sharing. About 3/4 of our audience says no. Now it's about 2/3 of our audience say no, but the yeses are starting to get more votes.
Okay, so let's see where people come in.
Okay.
Got a bunch of you still not voted yet?
Yeah, well, we've got a lot of them. So Leslie, what do you? So it's about 2/3 say no.
So that's right. It should not affect a victim's public ability to get public benefits. And I will mention that when people in the chat were talking about children, what's really important is if a victim has U.S. citizen or lawful permanent resident children or children who independently qualify for public benefits, even if the mother doesn't qualify, she can go in and apply for the benefit only for the children and cannot be required to answer questions about her own immigration status or provide her social security number, only the child's. And so there's a lot that is available for people through their children, but the other is, and that getting those for your children should not affect, if you're a battered immigrant, now going forward, because of VAWA 2013, it is absolutely clear that accessing public benefits as a domestic violence or sexual assault survivor will not affect, if you're applying for VAWA T or U, your access to lawful permanent residency in the end. And that's brand new. Okay, so going back to what all people get without regard to immigration status, a lot of you got these. They get crisis counseling and intervention, domestic violence abuse and child abuse, elder abuse prevention, child and adult protective services, crime victim assistance, short-term shelter or housing for the homeless, which is the main way that sexual assault victims will get shelter. They'll get it through the risk of homelessness, domestic violence victims, and runaway, abused, or abandoned children. We'll be talking more about that a little bit later. Health care services. They can get public health services. They can get treatment for immunizations, like kids' immunizations to go to school. They can get health care like emergency Medicaid and like childbirth that are necessary to protect health and safety, and I'll be going into more detail on that. If you are unfortunate enough to live in a place where there's a natural disaster, you can get disaster relief, help during weather conditions, soup kitchens, other types of life and safety programs are available as well. The other kinds of things unrelated to programs that are necessary to protect life and safety that are also available to people who are undocumented, and some of you mentioned this, elementary and secondary school education, WIC, school lunch programs, community services block grant programs. Those are things like ESL, vocational, things that are funded through that source are also available, and as I mentioned, immunizations for communicable diseases. So it's not just children, it could be other forms of diseases as well. So the kinds of services that are available, what happened was, and this becomes important for the extent to which state governments can reduce access to benefits to a certain extent is governed by the fact that in welfare reform in 1996, the Attorney General of the United States was delegated the authority to decide what kinds of services were deemed necessary to protect health and safety and therefore could not be subjected to any immigration restrictions, state or federal. Those are programs that are in-kind services, like all of our programs that we currently offer. So when you think about in-kind services, think about whether your program would turn somebody away who was the wife of the wealthiest person in your community who was abused or sexually assaulted. If the answer to that is no, you're offering in-kind services because it doesn't depend on the economic level of the people applying. And they need to be in-kind. Well, they're actually not dependent on income. In-kind services are not cash and provided at the community level. And that essentially what happened is that the welfare reform law, here's the text, vested the power in the Attorney General, and that states and service providers cannot act on the basis, cannot prohibit access. So if somebody is eligible, let's say somebody is eligible for, as a matter of federal law because they're a qualified immigrant, for public and assisted housing. The state can't say, no one in my state who's eligible as an immigrant can get housing. They can't cut off access to the federal funding, federal benefits that somebody's entitled to even if they may contribute money to that program. And we have some materials available. We do lots of technical assistance. So if you're running into these issues in your state, please give Rocio Molina or myself a call, and we can work with you to try to do advocacy at your community level. And we also have, we also have materials in our web library. If you type into the web library, you go online, there's a search box on the left-hand side. We'll be showing it to you in a minute. If you type in the word preemption, you will get a series of articles that we developed that were approved under our Bureau of Bureau of Justice Assistance grant, analyzing preemption, particularly after the Supreme Court decision in Arizona versus the United States. So, undocumented victims and children can access transitional housing programs. Yes or no? Let's take another vote.
Okay, so people are going ahead and voting. And vote not in the text chat, but on the box on the left-hand side. You'll see a little corner in the little box, and you can just click the piece. But we've got, Leslie, I'll just share the results right now. About 3/4 of the people say yes.
That's correct. That is correct. It's great to see this. Years ago, as we started doing training on this, a lot of people were saying no. There is in the materials, if you go under government documents in the web link that we're giving you, you will find a statement from Andrew Cuomo from HUD from 2001 that is the policy then, was the policy throughout the Bush administration, and continues to be government policy, that there should be, undocumented immigrants should be able to access public and transitional housing for up to 2 years. As to health care, the good news here is there are ways for undocumented immigrants to access health care. And we have, again, in the state-by-state charts that we're providing you in a relationship to this webinar, you can look at, and these, by the way, the state-by-state charts on health care were last done in 2010, and we, with the pro bono assistance of Morgan Lewis, a law firm, they have about 10 lawyers who are hard at work updating it, and we should have a 2013 version available in a month or so. But you can look up what's available in your state. But as a matter of federal law, people can go to HHS-funded public health clinics, community clinics, and migrant clinics to receive health care without restriction. There are state-funded programs. There are post-assault health care that's available through VOCA, and then there's emergency Medicaid. Now, emergency Medicaid is available only in cases where the person needs treatment for an acute medical condition. So that includes serious jeopardy or impairment of bodily functions or potential that could cause dysfunction to a bodily organ or part. Can people give us the answers to, if I were to say, what do you think is the most common way that immigrant domestic violence and sexual assault survivors use emergency Medicaid? Can you type your answers in the chat box? Pregnancy, kind of. Birth, yep. The two big ways, I'm seeing some of it. Let's see some more of your answers. Yes, so what you're seeing is that childbirth and serious injuries from the assault are the two biggest ways. They do not cover prenatal care or pregnancy. And we'll get into how, for example, if in fact a victim goes to a community health clinic and we'll talk about that in a minute. So what's available is, I'm sorry about the Hawaii part, I didn't take it out of the slide, except for those of you in Hawaii. Labor and delivery, acute care, urgent pharmacy needs, urgent, mental health care, like if somebody's suicidal, let's say, necessary to protect life and safety, and sometimes there's 72-hour release. Again, we have a state-by-state chart, so you can look up for what's covered by emergency Medicaid in your state, which is at the Go link that we provided under the state assistance and federal assistance programs. You can find the chart. So healthcare. If in fact you're working with an immigrant survivor and you want to know where she can get prenatal care, who's undocumented, where she can get prenatal care, what you can do is go to HRSA.gov, and you enter your zip code or her zip code, and you can find all of the HHS-funded community health programs that are required to provide services without regard to immigration status in your area. And as I talked about, immunization testing, VOCA-funded post-assault health care. There are only two states in the country where VOCA funding is not available to immigrant survivors. That is Nevada and Alabama. All other states, should I pause, David?
Yeah. I'm going to. I'm hearing a background noise. I'm just 1 second. I'm going to just get rid of that noise.
All guests have been muted. You can unmute your line by pressing *6.
Okay, and Leslie, if you can press *6 to unmute your phone. We just don't want to hear someone's hold music.
I'm back. Okay. Please, everyone, stay muted if you can. We'd greatly appreciate it. Okay. So at these HHS-funded health centers, what can an immigrant get in terms of health care, an undocumented immigrant? Or it could be somebody who's not only undocumented. These services are available for people who are totally undocumented, and it's available to any VAWA T or U victim. And for U visa victims, this is the way they would get, for example, prenatal care. So a U visa person who's filed for their U visa application, unless they're in a state that provides health care to people who are PRUCOL or people who are lawfully present, the only way to get access to health care is through these federally qualified clinics. So this gives you a picture of the kinds of services that are available through these clinics, and it's quite broad. Then, as I said, these are the lists, and here's the Go link again, so you can click on it. It's a live link on your computer on the webinar. And we have state-by-state charts of healthcare access, emergency Medicaid, forensic examinations, post-assault health care, prenatal care, TANF programs, child care, food stamp programs. LAHEAP is like the housing assistant, no, the heating assistance, and SSI. Well, for those of you that see SSI on the list and might get excited, you should know that very few immigrant victims actually qualify for SSI. That's the hardest program to get. So I was talking about the web library. If you go online and look at it live, this is what it looks like. I'm going to try, David, to use my little, there we go. So this is the way I use this, one of the most important boxes on the site is this search box. And you can literally go in and type benefits, state benefits, preemption, TANF, and you will get all the materials. You'll get chapters on the materials, you'll get sample materials, you'll get government memos and policies, etc. The other thing that's important is there's this manuals here. We've included at a link in your documents to the manuals. What this is we have a manual on the legal rights of immigrant survivors of domestic violence called Breaking Barriers, and a manual on the legal rights of immigrant survivors of sexual assault called Empowering Survivors. And those are all available online there. They're downloadable chapter by chapter. Across the top here, this is a little bit kind of confusing, but across the top here are some of our OVW approved materials that we've used for conferences and trainings. But again, one of the other places you want to go is you'll find a parallel library. I don't draw circles very well, but a parallel library right here at additional resources. And that tab will take you into a library with these various topics where you can look up the U visa or VAWA or trafficking, and you'll be able to look at public benefits, family law, immigration law. So please feel free to use the site. You'll find a lot of materials there that will be hopefully helpful to you in your work. Okay, another true and false, or yes and no. Immigrants applying for public benefits for their children can refuse to provide immigration or Social Security information about themselves.
So go ahead and vote in the left hand in the feedback box. So try just put it in the feedback box, yes or no. Let me share the results, Leslie. It's kind of overwhelming, the answer from this audience. This audience is saying yes.
Well, they are right. Good. That is true. In fact, what federal law says and I get a kick out of this one because I still haven't found anybody where this has happened to. And if it's happened to you, please let us know, because that would be good news. What's supposed to happen, imagine you're going into a public benefits agency with your clients, and you're going to apply, she's going in to apply for public benefits for her children. What the public benefits worker is supposed to do is, if the public benefits worker would like to ask Social Security or immigration information about the immigrant survivor herself, they're supposed to more or less say the following. Well, first of all, one good reason they might ask it is they might be thinking, well, I want to help her get more money. So I'm going to ask her because then I could give her more benefits if she qualifies as well. But whatever the reason is if you're representing an immigrant survivor or you're going in with her, and you should not send victims in to apply for benefits on their own for this reason. If she's asked, what she should say is, I'm not seeking benefits for myself. I'm not seeking to be included in the benefits grant. And then they shouldn't be asking any questions about her. If they insist, or if they decide they want to ask her questions about her Social Security number or immigration status, what they're supposed to say to her is, I'm going to ask you a question. When I ask you these questions, the answers you provide me, I'm required to provide to the Department of Homeland Security. Okay, now I'm going to ask you the questions. What's your Social Security number? What's your immigration status? Have any of you actually had that happen in a benefits office? Curious. I'd be surprised. I mean, I'd love to know who's doing it right. But we'll see as they go. No, I'm seeing lots of no's. One yes. The person who's yes, will you tell us where you're from? Anybody who's yes, I'd love to know where you're from. So yeah, it's good to see that sometimes they're doing what they should be, and that's probably as a result in those communities of good advocacy, people who've been working with your benefits providers and helping educate them about the law. That's fantastic. Okay. So we've talked about this. When a child qualifies, they're only supposed to ask questions about the child unless the parent is seeking additional benefits for themselves. Saginaw, Michigan. Okay. Vancouver, Washington. Fantastic. Okay. So the resources. One of the things that we try to do is provide resources so that when you go in and apply, you're working with an immigrant survivor, you can know before she goes what she's legally entitled to access, so that you're asking for things you know she already qualifies for. So in our web library, we have a chapter called Access to Programs and Services for Immigrant Victims of Sexual Assault and Domestic Violence, and it has a really good overview of all the different programs and goes through what undocumented victims can get, what victims who are lawfully present can get, what victims who are PRUCOL can get, what victims who are qualified immigrants can get, etc. It also goes in, we went in and we actually looked at every program funded by the Department of Health and Human Services and HUD, and we went through the list. So if you have a client who's a qualified immigrant, you can actually see all of the benefits they should be able to legally access. This is where you'll also find the HUD letter that we talked about earlier, and the Attorney General's order on programs and services necessary to protect life and safety. So when we talk about, as you're hearing, when we talk about qualified immigrants, we talk about who's lawfully present. It's all connected to immigration status. So what I thought I would do is just very quickly highlight which of these categories of immigrants are going to have more access to public benefits and which are going to have less. VAWA self-petitioners, trafficking victims have the most. VAWA self-petitioners on this list have pretty much the second most. Asylees, once they become refugees, have the same amount of access as trafficking victims, pretty much. People with battered spouse waivers, those are people who actually have a form of lawful permanent residency. How much access to benefits they have depends on when they entered the United States. If they've been here under 5 years, they'll be barred from TANF and food stamps and a number of other means-tested programs from for 5 years unless they're in a state that provides them in the interim. U visa victims will have to wait until approval. Special immigrant juveniles, I believe, now I'm trying to remember here, I think they have to wait until they get lawful permanent residency, which is at the end of their special immigrant juvenile. If there's somebody who can correct me on that, let me know, but I'm pretty sure that's right. Even I, who have been involved in writing a lot of these things, have to look up some of these things all the time. DACA, the Deferred Action for Childhood Arrivals, and the people with where they're low priority immigrants for removal will not have access. They'll be just like undocumented victims for purposes of access to public benefits. So let's talk about U visas for a moment. How many of you have worked with a victim who's filed an application for a U visa? Can you raise your hands? The hand button is next to the phone number in the top left.
Great. So I see, Leslie, we've got over 100 people have already raised their hand.
Great. So lots and lots of you are working with U visa victims. The most important thing to tell you about the U visa is that there is a new form of U visa relief that was added in VAWA 2013, which is stalking, which is right here. And so what this means in terms of access to benefits is, and we'll go over, I have at the last slide will be a list of states so you can see what's happening in your states. If you want to, in the meantime, look, and you can switch screens, you can look up in the lists on at the Go link, you can look for the benefit and it'll tell you what's available by state. In that same state-by-state federal assistance programs, we also have developed materials which go immigration status by immigration status. If you're working with a U visa, we have a tool now that you can look at, and it has all of the different federally funded services and benefits that are available to U visa victims. We have a separate one for VAWA applicants, VAWA self-petitioners, cancellation and suspension, who all have the same amount of access to public benefits. One thing about VAWA cancellation and suspension, I know I'm showing the U visa slide just so I don't forget, that's really important, is that if you're working with a victim, or if you're an advocate working with a victim and they have an immigration lawyer, you're the lawyer in the immigration case, many immigration attorneys don't know that there's special rules for immigration judges in granting essentially a prima facie determination so victims can get early access to benefits without having to wait until their case is adjudicated. Again, that's up in our website. If you go to our website, there's a section on materials for judges, and if you look at what we've posted for immigration judges, that memo is there. A lot of the immigration judges didn't even know that they had the power to do this. And so it's really important. You may be the person that can tell the lawyer working with the immigrant victim who's in a case before an immigration judge that they should be filing a motion and asking for a benefits determination so that she doesn't have to wait to get benefits. Anything else on that, Rocio? Okay. Okay, so U visa victims. They get, as I said, depending on the state, access to some benefits. It's very state dependent. Once it's approved, they get access to health care, but they are not qualified immigrants for purposes of accessing public and assisted housing, etc. The issue of post-secondary educational grants and loans for U visa is an open question still. It's under consideration at the Department of Education, but no determination has been officially made yet. So if you're working with U visa victims, how many of you are working with U visa victims that need access to public and that need access to post-secondary educational grants and loans? Can you raise your hands or type in the chat box? I'd be very interested to know what you're seeing out there in terms of that. So we're seeing a few of you, no, not so few of you, actually quite a number of you. Let me say that if you have a client who would be willing to share their story, if they're a U visa victim, we would love to get a sense of what those stories are like to be able to better help those victims in trying to access benefits. The other thing, in terms of post-secondary educational grants and loans, one of the things we did a couple of years ago, and we haven't quite finished this database, is we can provide, if you're working with, let's say, an immigrant victim who has applied for deferred action for childhood arrivals, let's say DACA, and they want to go to school, to university. We have collected some information. If you email us at info.nuep.org, we can provide you information about programs that we know are funding post-secondary education, well, funding student loans and grants to students to go to school in your community. That's something we're hoping to get in an up and running database in the months to come, but we haven't quite gotten there yet. Okay. So what happens is that as we talked about U visas, and we talked about VAWAs and Ts and access to public benefits, the only way victims get access to public benefits is that they have to file the immigration case first. Public benefits beyond what they get being undocumented. So they have to file the application for immigration first. So one of the mantras, those of you that have been on these calls with us, is that you often hear us say, screen early, gain the trust, find out if she's undocumented and she's a victim, so that she can get these cases filed as soon as possible. Because the sooner you file the case, the sooner she'll be deemed PRUCOL lawfully present, if there's a state that covers that. This is where, for example, in states that are more conservative but do grant something, one of the main things they grant is prenatal care. So if you're working with an immigrant survivor who's pregnant, you really do want to get these immigration case filed as soon as possible if you're in a state where that will trigger access to prenatal care, for example. So you want to file the immigration remedy so that somebody is on the path to becoming, to gaining, to working their way up the chain of what they're able to access in terms of public benefits. So now we talked about what's available to undocumented victims. We talked a little bit about what's available to, and we'll go back to state benefits in a little bit. We talked about what's available to people who are lawfully present or PRUCOL. And now we're going to focus on, okay, if you're working with a trafficking victim or you're working with a VAWA self-petitioner, a VAWA cancellation, or a VAWA suspension applicant, basically you're working with somebody who can be a qualified immigrant, which gives them much more access to benefits than they would have if they were not. So if you're working with, let's say, a VAWA victim, VAWA self-petitioner, and she's filed a police report, so you could actually file a U visa case or a VAWA case. One of the reasons you want to file the VAWA self-petition as opposed to the U visa is more access to public benefits. So that's one of the major differences between those two cases. But which benefits an individual client that you're working with who will be a qualified immigrant gets depends on, as I talked about earlier, the immigration status, whether she's qualified immigrant, lawfully present, or PRUCOL, when the immigrant victim first entered the United States, and we'll get to that in a few minutes, and whether they meet heightened program requirements. So SSI, food stamps, TANF are harder to access than housing or post-secondary educational grants and loans. And then it also depends on what state you're in. Okay, again, just to review, U.S. citizens get the most, qualified immigrants get the next most. That's probably not the best way to put it. Undocumented immigrants get the least, and people who are lawfully present or PRUCOL can potentially get some benefits, if not some benefits that are less than what qualified immigrants would get, but they get it from their states. So let's talk about how benefits restrictions, federal benefits restrictions are structured. Only programs that, as a matter of law, have immigrant restrictions are the only ones that are matter of law are restricted in terms of immigrant access are things that are deemed federal public benefits or federal means-tested public benefits. So this is the list of federal public benefits, okay? So it covers your income support benefits, welfare and retirement, health, disability, education, housing, food, unemployment. On the other thing it covers are grants, loans, that's where you get your educational loans, and licenses, which includes driver's licenses. So we have immigrant victim access to driver's licenses, we know, has been a problem that has been coming up in the field a lot. Many of the forms, the typical forms of documentation that a survivor will receive between the time she files her VAWA self-petition, for example, and the time it's approved may not be recognized, and it may need to do some advocacy with your state driver's license agency. We decided to track it state by state so you could see all the different forms of benefit of documentation and different ways that you can prove it. Any of you that are on this call from the state of Maine, you should know that you have the best driver's license laws in the country when it comes to immigrant survivors, and VAWA T and U visa victims have access to driver's licenses quite early in the process compared to other parts of the country. But you can see that, and again, we can provide you technical assistance and help you walk through the process of what might be available in your state. Okay. And here, I forgot we did this, David, is a copy. This is only the first states, but it gives you a sense of how we're documenting this, what kinds of paperwork various states accept. And this will help you think through what your client may have available to her. And for a lot of people, you'll notice here that one of the things that most states accept is an employment authorization document, which is something that if you're working with a VAWA self-petitioner who's married to a U.S. citizen, they usually get those within the first 3 months after filing. Everybody else who's a VAWA self-petitioner in terms of getting access to work authorization will only get it at the time their case is approved. The average wait time for DHS adjudication right now for VAWA self-petitions is averaging about 18 months. It can last as long as 2 years. U visa cases usually are averaging about a year. They can last as long as 18 months. And so this is a big issue that we would, we need to kind of be there, and as technical assistance providers, we'd love to work with you and support you and think through of what you can do during this wait period to help immigrant survivors. Okay, to be only considered a federal public benefit if the payment is made directly to an individual, a household, or a family eligibility unit. So if you want to know why your program, which is federally funded, is not considered a federal public benefit, is because your program doesn't meet this definition. So it has to be a payment or assistance to an individual, a household, or a family eligibility unit. These kinds of programs are not considered federal public benefits, which is why they can serve everyone without regard to immigration status. There's also state-funded benefits, and what's interesting about the state-funded benefits is that in 1996 welfare laws gave states the authority to extend benefits to non-qualified immigrants, so undocumented, although very few do, but survivors of domestic violence. A number of states have added that, Iowa being a good example, where they have extended it to victims of, I believe it's domestic violence and sexual assault. Again, our charts that we have, you can see state by state TANF, healthcare, food stamps, SSF, SSI, and childcare. The Go link is again here for you. So who are qualified immigrants? There's a whole range of people. It's not just VAWA self-petitioners. How many of you are working with immigrant crime victims who have lawful permanent residency or have some other form, might be a refugee or an asylee? Can you raise your hands? How many of you are working with lawful permanent residents or refugees or asylees? Because we always talk about immigrants being the ones that are undocumented, or the VAWA self-petitioners, or the U visas, but we're also often seeing, and I see at least 10 or 20% of you, maybe more, are seeing cases as well of immigrants who have different statuses. And so one of the things to know is if you're working with a lawful permanent resident, or if you're working, thank you for raising your hands, if you're working with a lawful permanent resident, or you're working with somebody who is in a conditional, has what's called a conditional green card, a conditional permanent residency. That's somebody where if you look at their lawful permanent residency card, what you will see is that that it was issued, that it expires 2 years after it was issued. If somebody has that card, they are qualified immigrants, just like VAWA self-petitioners. And this gives you a list of some of the other kinds of qualified immigrants that you might encounter. And so basically, how does an immigrant prove they're a qualified immigrant? So I'm going to go through the kinds of qualified immigrants that are which groups of immigrant survivors can get access to public benefits as qualified immigrants. And one of the reasons a minute ago I was talking about lawful permanent residency and conditional permanent residency is people who entered the United States after August 22nd, 1996 are subject to what's called the 5-year bar. They have to wait 5 years before they get TANF. They have to wait 5 years before they get full access to Medicaid-funded health care. They have to wait they have to wait 5 years before they'd be eligible for food stamps, for example. And so what happens is trafficking victims do not have, however, that 5-year bar. So as to immigrant survivors who are qualified immigrants, there are 3 categories. You have people who have filed their VAWA self-petition and have a prima facie determination, which is that piece of paper that comes after around 3 months after you file. You have VAWA self-petitioners who've gone through the whole process and gotten approval. They're also eligible as qualified immigrants. They remain eligible, essentially, as qualified immigrants. And then you have people, sometimes you'll have cases where the perpetrator filed immigration papers for the victim, and she received conditional permanent residency, or she received a full green card. And when she did, she was subject to the 5-year bar. Okay? So, and she still would be. But the point is that there are deeming rules, and there are rules under regular public benefits access that say that if you're going to access benefits, they're going to take into account your family income. And what happens is that with an immigrant survivor, if you do that, you take into account the batterer's income. And so there are deeming exceptions that are available. So you would be working with a lawful permanent resident that if she were just applying as a lawful permanent resident for benefits, she wouldn't be eligible because of deeming. But if he's filed papers for her and she's waiting approval on a lawful permanent residency application, or she's received lawful permanent residency, she would be eligible to the deeming exemption as a battered immigrant. Now, in addition, normally if she's filed a lawful permanent residency application and she's awaiting, it's approved, but she's awaiting her green card, she doesn't have it already, in a normal process, a non-battered immigrant would have no access as a qualified immigrant. We were able in 1996, when we wrote the benefits laws, to say that if she has an approved application that was filed by her perpetrator, she is also a qualified immigrant. So there's a small category of people that are in the process of getting their papers through their perpetrators. They might not have filed a VAWA self-petition. They might be so close to getting lawful permanent residency that they want to try to go forward with the case with the abuser. Those of you that are working with victims who are still living with the perpetrator, they may want to go along because he's filed with her and just go along with that process because she has secretly filed for VAWA with confidentiality and doesn't want him to know. And so she would actually be able to get some access to public benefits without having to wait until she actually received approval. I know that's complex. I hope I was able to clarify for people. There are, again, our materials, our chapters describe this in greater detail. Okay, so in addition, for when a battered immigrant, there are some immigrant mothers who would be filing a VAWA self-petition based on the fact that their child was abused. They cannot get benefits they must show that they didn't actively participate in the battery or extreme cruelty of the child. The reason that language about active participation was chosen is we wanted to craft the law so that women who are unfortunate enough to be in states where they are wrongly charging battered immigrants with failure to protect are not excluded from benefits access. So to get benefits as a battered immigrant qualified alien, you have to show that you're one of those categories. You're either a VAWA self-petitioner, approved VAWA self-petitioner, or cancellation of removal or suspension of deportation, or you are have an approved family-based visa petition, you have evidence that you've been abused, and you're in the line waiting for your green card. Then you have to show that there's a substantial connection between the battery, extreme cruelty, and the need for public benefits. The people at the Department of Justice in the Clinton administration did an amazing job in articulating what that list is. I'll show it to you in a minute. And finally, this is the only place in VAWA where you can only get the benefit if you're separated from the abuser. Okay? So the Congress didn't want the abuser to be able to get the funding for the benefit while the victim was still living with him. So in order to get public benefits, now you might think, how can she leave and then just file for benefits? How can she be safe? Well, in the materials on our website, if you type in public benefits and get to the main public benefits section part of the website, you will see something called the, it's guidance to the states on verification with regard to how do you determine whether somebody is a qualified immigrant and who can access benefits. And in that guidance, it's called the Attorney General's guidance, and in that guidance, you type in guidance, you should find it on the website. You will see instructions that the Attorney General of the United States, the Justice Department, is recommending to states that they actually do predeterminations of benefits eligibility so that the victim doesn't have to flee the home without knowing that she will get benefits when she's separated. So then some states, and I think Illinois has the best laws on this, she can actually go in, and this is what the Justice Department recommends, is that she goes in, gets her benefits determination, and some states will even start the benefits and require that she comes back a month later and shows with a protection order or some kind of other evidence to show that she's no longer living with the abuser. Other states will basically make the determination that she's eligible and then only start the benefits when she comes in with evidence that she's separated from the abuser. And again, our materials on the website talk you through how to go through that process and explain it in greater detail. Substantial connection. The factors used to determine substantial connection, this is one of those great things that one of the reasons that I find my career so much fun is that we work with really, really great people, not only like you guys in the field, but with allies, people in government who are really doing the right thing and really care about the right thing for survivors of domestic violence, sexual assault, and human trafficking. And they created this list, and without reading it, all of it, you have it on the screen, you can see it is a pretty comprehensive list. It includes when the victim's fear jeopardizes the victim's ability to take care of her children or to keep her job, or his stalking of her, for example, causes her to lose her job and she doesn't have income. It covers medical care during a pregnancy that results from the relationship with the abuser. So it is very, very broad in terms of what's covered. So if you've gone through this process and you have a victim who's filed a VAWA self-petition, or you have a victim who has in the process of getting VAWA cancellation or suspension, or they're a qualified immigrant, trafficking victim or otherwise, lawful permanent resident who might be a qualified immigrant, what do they get? What do you get when you're a qualified immigrant that's more than what you get when you're undocumented? You get public and assisted housing. You get access to post-secondary educational grants and loans. Let me talk about each of those briefly for a moment. Do I have more detailed slides on them? As to public and assisted housing, if you have difficulty, we're still working to get guidance out of HUD to confirm. There's actually not been a policy issued by HUD since the law passed in '96, confirming affirmatively that battered immigrant qualified aliens get access to public and assisted housing. In many communities, people are able to do it. Again, how many of you have been able to get access to public and assisted housing for battered immigrant qualified aliens in your community? Can you raise your hand? Huh? You don't have anything else on. Okay. A few of you. That's good. Okay. Looks like any more? Keep answering. I'd love to see the response. Great. So it sounds like some of you are. It's not that many. It doesn't surprise me. There are some communities where they've tried to do it and have not succeeded. There are policies that are being developed as we speak, is my understanding at the Department of Housing, in which they're trying to confirm this and get a policy out. We've been waiting for that policy for quite some time. There are proposals in comprehensive immigration reform, or that people are trying to get into comprehensive immigration reform that may remedy this problem. So if you run into this, please call us and we'll see what we can do and can walk you through what you need to take in to try to get it in your community. Alternatively, if you have a case of an immigrant survivor who is not able to access and you're willing to share her story with us, we would love to collect those stories. And so you can email those stories to info@newapp.org. Or you can email us and we can have one of our law students call you this summer, and they will follow up and you can tell us your story and they can draft it and you can edit it. We'll try to facilitate making those happen if you're able to share with us. Post-secondary educational grants and loans. VAWA self-petitioners as qualified immigrants get access to post-secondary educational grants and loans. There are materials in the letter that Department of Education wrote to all of the universities in the U.S. that documents that fact is in the materials for the webinar under government documents, and you can use that to facilitate access. Again, if you're working with U visa victims, there has been no policy yet about the extent to which they will be able to access post-secondary educational grants and loans, but we should be hearing something on that shortly. Okay, so the other thing that happens is qualified immigrants get access to subsidized child care. I'll be talking more about the different forms of child care available in a few minutes. They get access to low-income residential energy assistance, disability benefits, foster care. That means if they're a foster care parent for, let's say, a family member, a child of a sister or a brother or something like that, or even a non-family member, they can receive foster care payments if they're a qualified immigrant. Okay. Does DHS require universities to ask about immigration status of the applicants or enrolling students? Yes or no? What do you guys think?
Okay, Leslie, Leslie, just doing a little time check. We only have 15 minutes remaining, and I know a lot to cover, but let me share the results. That about 2/3 are saying yes, and 1/3 are saying no.
Okay. Tell me what slide I'm on. Okay, so the answer is DHS does not require universities to ask about immigration status of the applicant or enrolling student. So if you go to our web library and you type in education, or you go to the public benefits section of the new app, additional resources, and click on public benefits, you will find the letters that DHS, the policies that DHS has issued in confirming that they have no such requirements. The only group of students who they are required to ask immigration status about are the students who are foreign students on student visa. Okay. Okay. So, in terms of post-secondary educational grants and loans. So what those policies say is, first of all, if they're battered immigrant, qualified aliens, or T visa victims, they're eligible. Universities have to accept the documentation from DHS or the immigration judge. If they want to apply, they do a FAFSA application, and they put eligible non-citizen and provide their A number. What will happen is DHS will do this, the university, DHS or DOE will try to do a match the match will fail. They always fail, and they fail because of VAWA confidentiality, because the information isn't in the matching computer, and that actually verification is not required. So if you, again, go to the policies, we can facilitate access. You can help facilitate access for VAWA victims. Okay. So let's talk now about other federal means tested. Federal means tested public benefits. So what happens? We talked about the ones that you can get with right now without any restriction, no 5-year bar. Federal means tested public benefits has a 5-year bar. That means from the time you get your your qualified immigrant status, you have to wait 5 years to get TANF unless you entered the United States before August 22nd, 1996. And how many of you still see clients who entered before August 22nd, 1996 who are VAWA self-petitioners or U visa victims? I'm just curious. I'll talk while you vote. And David, you can summarize that in a minute. So SSI is the most onerous. It's very difficult. If you have a client who has been here for a long time, we have instructions and information about who qualifies here in the slide in our materials. Food stamps is a very interesting one. This is another, food stamps provide another reason where if you're working with an immigrant survivor who has children that she can include in her VAWA self-petition. What's really important about food stamps is that they that their children under the age of 18 immediately qualify when they get the qualified immigrant status. So again, people for food stamps, they get more access than others. So it's a qualified immigrant who's been here for 5 years. Again, you might have somebody who got qualified immigrant status when they were applying for their VAWA application. It's now approved. They've got an approved VAWA application. They're waiting for their green card. But if they've been here for 5 years in that status, then they would become eligible for food stamps. In terms of health care and health care reform, I want to summarize a few key points as to immigrant victims that you're working with. Naturalized citizens are the same as U.S.-born citizens, so people who were here as foreign-born but naturalized get the same access to health care reform as everyone else. Legal immigrants are subject to the individual mandate and tax penalties unless they're low income. People who are lawfully present that get health care are VAWAs with prima facie, VAWAs with approval, U visas on approval, trafficking victims at the early point in their case when they get ORR certification. That comes earliest for trafficking victims when they have gotten continued presence that the federal government applied for her. They may do continued presence first to get the benefit access and then apply for T visas. And when they apply for T visas, they also become eligible as qualified immigrants. People who are lawfully present for healthcare purposes are eligible for tax credit. They can buy insurance through the state insurance exchanges they're being set up with no wait, and they are eligible for the state's temporary high-risk pools, but they still have the Medicaid bar for qualified immigrants unless they're for non-pregnant adults. So what you get when you're lawfully present, if you're pregnant or you're a child, you get access to health care. So this is where prenatal care comes from for lawfully present immigrants on this list. Undocumented immigrants, as I said earlier, they continue to get access through HHS-funded health care programs. They're exempt from individual mandates, and they cannot purchase insurance for the state income tax exchange. They get no access to full Medicare, Medicaid, or CHIP, and they get no tax credits. Citizen or lawfully present children of undocumented immigrants can purchase child-only coverage on the state health care insurance exchanges. They're eligible for premium tax credits and reduced cost sharing, and may be eligible for Medicaid or S-CHIP depending on the state. So federally funded, so as to people who are pregnant, there are the people who are lawfully present, again, includes a long list of people who are lawfully present for healthcare purposes. This reviews what I had said earlier. And thank you, Krista, for helping answer some of these questions on the chat as we're doing this. Krista is one of our nation's experts on, Krista DeGallo from Texas is one of our nation's experts on public benefits and a real great resource. Anyway, and the other group of women, here's where you see all the victims who additionally get a summary of the victims who get access to, for lawfully residing, who get access to child health care and prenatal care. And for those of you joining us from Hawaii, I saw a number of you were there. This is where Micronesian and Marshall Islands and Palau folks get access to prenatal care. Child care, getting towards the end, and one of the things I wanted to talk about is there's a lot of misinformation out there in the field about access to child care. How many of you have been able to get your clients, I see clients, David, if you can reset the hand again. I want to ask another question, and that is how many of you have been able to get access to state or federally funded child care for the clients that you're working with, either through child care development funding or TANF funding? I'm really curious for the outcome of this, so I'm going to wait a second. So some of you, in fact, are. This is absolutely one of the things that's very important is child care development funded child care is available to any qualified immigrant or qualified immigrant or citizen child, and it goes by the child's immigration status, not the parents. So a lot of the parents you work with are going to be eligible because of for their U.S. citizen or lawful permanent resident or qualified immigrant child for child care, child care funding. And some of the details of how you get there are how you get here important. One of the most important things is that the state agencies cannot require a Social Security number for a person seeking CCDF funded child care, and cannot deny benefits to families that don't have Social Security numbers, even if the money that is funding the CCDF program in your state is TANF money. Okay, so CCDF funded child care is open by and large to a lot of immigrant victims and their children. TANF funded child care, and this is another one of the state charts we developed. They vary access to TANF funded child care. Not only are there federal rules, but some states also provide access to TANF funded child care. If they provide access to TANF, they usually also provide access to TANF funded child care during the 5-year bar. And so this is another area where immigrants can get access to child care. So I'm going to kind of summarize. We made these cute little graphics of who qualifies, just to summarize what the process is for applying. So if you're a VAWA self-petitioner, the point at which you first get, oh, I drew an arrow. The point at which you first get eligibility is at the prima facie determination, about 3 months from filing. And then you also get it at approval. At that point, you're qualified. And the next question is, how long has she been here? Pre-96, you get access to most things, including TANF and all of that. Post-96, you have to stop and figure out, does she have a way to deal with the 5-year bar? Are you in a state that provides access? Is she lawfully present? She's lawfully present, so she can get health care. What can her children get? And that's how you go through the VAWA self-petitioner analysis. Going through for trafficking victims, you will see that the key here, everything flows from here. And that is getting something from the Office of Refugee Resettlement, a certificate from Office of Refugee Resettlement, saying that you are eligible for benefits. And you can get that through continued presence from law enforcement or you can get it from a bona fide letter from after you filed your VAWA, your T visa, and you can get it from approved T visas. And the certification is a certification for adults or an eligibility letter for minors, and that from that point on, in most states, you can, at that point on, you can get pretty much everywhere public benefits access similar to what refugees get. And the story that's not so fun is U visas. U visas have the least access to public benefits, and this summarizes how the process works. They have lawful PRUCOL. They get PRUCOL is the first step after they file. Then after they are approved, they get lawful presence. If they are, and then what happens is you go here, and it depends on what, it really turns on essentially what the states do in the end. Not qualified immigrants have no access to federally funded benefits, except U visa holders get health care. And then in whether they're state benefits, lawful presence, or PRUCOL sometimes equals public benefits. And then there are many other states where non-PRUCOL, or states that just don't give anything. And so we've been talking about states, and I thought I would leave this up during the question and answer period. This is in the materials, in your state-by-state charts. There are various different qualifications and restrictions on these things depending on your state. So for those of you joining us from Florida, for example, TANF access, I believe it's in Florida, or it's either TANF or healthcare. I think it's healthcare access in Florida, depends on your county. It's the only state that I think operates in that way. But as you can see, the greatest number of places where qualified immigrants and immigrant victims who are lawfully present would get access to health care is happening in health care. And some states, if it's the most limited, that turns on prenatal care or child health care. Some states are quite broad. It depends on the state. And the materials, if you look up the VAWA self-petitioner list where you see the process of the benefits application and what she gets, we actually have footnotes in that materials where you can see state by state what exactly are the restrictions, what are the definitions, etc. If your state doesn't appear on any of these lists, you have no state-funded options, which means, I'm going to go back for a moment, oh it does work, which means that as to the 5-year bar, you can't, all your clients get are food stamps if they have kids and health care. If you're trafficking victims, you're okay. If you're a U visa victim, basically all you get is health care upon approval. And both the VAWA self-petitioners that only get, the U visa victims, essentially you have to wait for health care and you have to rely on what is available to undocumented victims in the meantime. Okay, David, I'm going to open it up to you for questions.
Well, we only have 2 minutes left, and so there's a lot of questions that have been in the text chat. How will you be able to answer some of those questions if someone wants more information?
Okay, so what we're going to do, we're going to try a new process this time around. We're going to create like a Q&A document that all the questions that you've been asking and has gone through that have not been answered in the chat, and even some of those that have, we're going to put together the questions and then we're going to give you written answers and we're going to circulate it. We're going to post it with the materials on the website for you to download and circulate an email notifying you that the materials are available. They'll probably take us into the beginning of June because we're here at a university and the students are all about ready to disappear to take finals. But we will develop that and get it out to you as soon as you can. If you're working on a case right now and you need the answers sooner, please email us your question at info@nuapp.org, and we will we will get back to you as a technical assistance call.
Okay, so it's info@nuapp.org. I am putting that, of course, into the text chat. And I really want to thank you, Leslie, for joining us today for this really wonderful. I want to thank Rocio Molina, who on the back end has been answering a lot of the questions in the text chat. And thank all of you for your really vibrant questions that you've been asking. here highlight that there's other national technical assistance providers that are available, and so I want to encourage you to be able to contact them, and you can always, of course, follow up with NUAP. So thank you, Leslie, so much. I think this was a really informative session, and want to thank everyone here, and I see a lot of thank yous going on. You can get copies of these materials, so it's great.
Get a copy. We'll have a copy of the text chat. We'll have copies of the materials. And we have copies of the web. We will post a repeat of this web presentation in this, along with the PowerPoints and the materials after the webinar. David, how long does that take approximately?
We'll get it in the next day or so.
Okay, and just please, if you're downloading it, have some patience. It's a giant-sized file, so it's a little slow in loading up. Your computer is not broken. It just takes time.
It just takes time, and you will be receiving an email in about a half hour with an evaluation of today's session, also including links to get the information. So thank you very much, Leslie, and this concludes today's web conference. We'll keep the text chat open for a couple more minutes, but thank you all for joining us, and look forward. There'll still be one more webinar in this series, and so we look forward to seeing you in the future. Thank you very much. This concludes the audio recording of today's web conference.